Welcome to this exciting series on respect in the workplace. Something you might not know, in the United States, 95% of McDonald's restaurants are actually not owned and operated by McDonald's. They're franchised restaurants. Even though you work at a restaurant displaying the famous golden arches, may wear a uniform branded McDonald's, and prepare food served in McDonald's packaging, you actually work for an independent business owner called a franchisee, or an owner-operator. That means that the McDonald's restaurant where you work is run by one of the thousands of independent local business owners who own and operate McDonald's brand restaurants across the United States. Many franchisees got their start just where you are, working in the restaurants. What does it mean to be a franchisee? McDonald's provides every franchisee access to the world's greatest restaurant brand, but McDonald's is not your employer. Your franchisee and their restaurant team decided to interview and hire you. They are solely responsible for all the terms and conditions of your employment, including your pay, schedule, job duties in the restaurant, how to perform them, and more, including handling any concerns you may have. Your franchisee chose to offer you this learning experience because your franchisee, like McDonald's, believes that everyone should work in a safe, respectful, and inclusive workplace that is free of discrimination, harassment, or retaliation. The examples and information contained in this learning series provide suggested approaches and practices to build respectful restaurant workplaces.
If you have any questions about the episodes or your restaurant's policy and practices, including who you should report concerns about potential policy violations to, please contact representatives listed in your restaurant's policy. Your franchisee has a policy that explains who you can contact to share any concerns, like a manager, a staff member, a hotline, an email address, or the franchisee themselves. Before you dive into the series, here are some important concepts under the law. Federal and state laws make it illegal for employers to discriminate against employees based on certain protected characteristics. Discrimination is treating a person or group differently than others because of a trait the person or group possesses, including race, color, religion, sex, including sexual orientation, gender identity or pregnancy, national origin, age, disability, genetic information, or other traits protected by policy or local law. For example, discrimination is refusing to hire a person or paying them less based on these personal traits. This protection against discrimination applies to all types of job decisions, including hiring, firing, promotions, training, wages, and benefits.
The law also forbids harassment based on any of the previously mentioned categories.
Under federal and applicable state laws, for inappropriate behavior to rise to the level of illegal harassment, it must be unwelcome or unwanted. It must also be severe, meaning very serious, or pervasive, meaning that it happens frequently. Inappropriate behavior is also illegal if it results in your employer making an employment decision about you, such as refusing to promote you or demoting you. Examples of harassment may include, but are not limited to, offensive jokes, insults, abusive or offensive names, name-calling, physical assaults or threats, intimidation, ridicule or mockery, insults or put-downs, offensive objects or pictures, and intimidating behavior that impacts your work performance.
Sexual harassment is also illegal and includes conduct that is sexual in nature, such as sexual jokes, photos, touching, or requests for sexual favors, especially when agreeing or disagreeing to such behavior may impact your job. And non-sexual conduct that is based on gender, such as comments that men or women don't belong in certain jobs, or comments questioning men's or women's skills or abilities. Harassment based on sexual orientation, pregnancy, or gender identity is also not allowed. Sexual harassment can occur regardless of the gender, masculine, feminine, etc., or sexual orientation of the people involved. The restrictions against sexual harassment apply to employees as well as vendors, third-party delivery drivers, and customers. Sexual harassment is not tolerated even if it takes place outside of the workplace, such as when you are socializing with coworkers, outside of work, or at an event sponsored by your owner-operator.
You have a right to complain about treatment that you believe is illegal job discrimination or harassment. Your employer cannot retaliate against you, which includes punishing you, treating you differently, or harassing you for reporting or helping someone else report, even if it turns out the conduct was not illegal or against policy. This is called your right to be protected from retaliation. Examples of illegal retaliation include firing, suspending, or demoting an employee, paying an employee less, or increasing an employee's workload.
Your owner-operator maintains a policy against discrimination, harassment, and retaliation that goes above and beyond legal requirements to ensure everyone works in a respectful environment. Take the time to review your owner-operator's general policy and any additional policies for your workplace. The policy should have been shared with you as part of your onboarding process. If you are a manager, you have a legal obligation to report conduct that may be considered sexual harassment. If you witness conduct that may be sexual harassment, you must report it even if the victim spoke up in the moment or you believe the victim has already filed a complaint or reported it. Remember, this learning series is important to help you understand the topics mentioned in this video and how you can help create a safe, respectful, and inclusive workplace for yourself and others.